Okay, when there is a new person taking it over, then he will start only from CP2.
No, sir. He will start from, because changeover happens in CRP2 itself.
Okay.
So the RP will start from CP3, CP4.
CP3 means CP2, it will come in the new,
yes,
new
yes,
one.
CRP3 and CRP4.
So he will come, RP will come into the picture from CP2.
Yes, yes, sir.
Okay. So I think, sir, just give me a minute. So we will just run through and then we will see the form, sir.
Okay.
So the dispensation, what they have proposed here is that CP1 will take care of the public announcement and also holding of the meeting of COC and also change in the IRP to RP. And then CP2 will take care of the entire process just before the filing of the resolution plan with the adjudicating authority. Am I right, Raghu?
Yes, sir.
So it includes like IM, RFRP, IM, EOI, RFRP, all those things will be coming into play there in CP2 form. And here again,
in CP1, as you have rightly mentioned about the replacement of IRP to RP or appointment there of confirmation of appointment. So, sir, shouldn't you think that there should be a column as well wherein if there is a delay in appointment or confirmation by the IRP to RP? Because in many cases, the IRP is not confirmed during the entire CRP period, and at the end, when the resolution plan is going to be approved, then they consider IRP as a RP.
Yeah. Yeah, true, correct. Are you asking whether a provision is there in the form to take care of this?
Yes,
delay? Yes, we will just show you the form contents and we will see whether it answers, Raghu. Huh? Okay. So CP3A will capture.
There should be just one thing. There should be a column as well that whether you have been confirmed as IRP to RP or not.
Okay. Okay, taken note. So CP3A will capture the details of application filed with adjudicating authority for approval of resolution plan, liquidation or closure. So this information, whatever is proposed to the adjudicating authority by the COC will come here. Yes. All this information. 3B will capture the details of order of adjudicating authority. Approval is issued by the AA. Then in that approval order, what all the information is captured, those things are all covered in CP3B.
So earlier in CP5, only after filing CIRP4, we can file only CRP5 once you get the order from the adjudicating authority, either approving the resolution plan or the liquidation.
Okay.
But now the CRP, because from CRP4 to CRP5, there will be a very long gap in most of the cases.
Okay.
So they splitted out that CRP5 into two stages where you file an application. You intimate to the IBBI that I have filed the application.
Okay.
And now after approval, CP3B will come into picture.
Okay.
Earlier it was only after approval of the resolution plan you will be filing CRP5.
So here the idea is that they are capturing the information. How many CP3As have been filed by the RPs?
Yes.
Then they will know this many resolution plans are waiting in the pipeline. Probably that monitoring of the judicial system of disposing the resolution plans. I think the idea is to one, capture the information without duplication. Second, monitoring it, and also to use it for effective, improving the system or cutting down the delays. That is the idea. CIRP 6 is proposed to be dropped. CIRP 6 was earlier capturing information relating to
specific events with relating to applications filed with regard to extension, exclusion, everything.
Okay, so that form is completely proposed to be dropped, but then the information relating to avoidance transactions are being captured in here in CIRP 8. Now they are capturing it.
Now in CP4.
Correct. Then CIRP 7 form is now revamped into CP5.
That is the status
is the delay happening and status happening. Now, can we show the form? What's the next slide? Okay, so timelines. Yes, this is the important one. The CP1 form to report certifying constitution of the COC is filed with the adjudicating authority under Regulation 17(1). This is the information.
It clarifies the question.
Correct.
Once one person has quoted,
correct,
who will be filing the CP1?
Correct. So this is to be done by the IRP.
IRP.
And this is to be done 10th of the succeeding month.
Yes.
So between 1st of, let's say, June to 30th of June, on any day, the report constitution of COC is filed with the adjudicating authority.
Yes.
The CP1 has to be filed by 10th of July.
Yes.
Right?
Yes.
Even if they would have filed it on 1st of June, the COC constitution report, 1st of June, the due date for filing the form is 10th of July. So they get a longer date.
Yes.
But I think it's only to make it uniform. It's only, the idea is to make it uniform so that by the 10th, I will be ready with all my files in one place so that I can just push everything. So CP2 is a report, the issuance of RFRP. Again, the same kind of timelines is involved for them. So there again, 10th of the succeeding month. So these are all becoming now time-based kind of filing the
except
forms.
for
Except 3B.
3B.
Except 3B. Okay. Because it is based on the adjudicating authorities' approval of the resolution plan or liquidation. Okay, CP3A, 3B. 3A, we saw that it is on the COC approval, right?
Yes.
Resolution plan or liquidation or process. So there again, it is 10th of the succeeding month only. And CP3B, we saw that, adjudicating authority approval. So here only it is going to be based on, we cannot say when it happens, add 7 days from there and file it immediately. The idea here would be approval of a resolution plan should be probably captured immediately within 7 days. Probably that could be the idea to get the form CP3B.
Because that is the closure of the process, entire process. That is the closure.
So it's not possible to fill up the information, all related data within 7 days.
That is what
the
suggestion.
Yes, that is the constraint highlighted by some of the participants. But we will look at CP3B, what is the information they are asking and whether it is reasonably possible to complete it or give it within 7 days. Humanly possible or systemically possible, we will see. And CP4.
If RFRP is delayed, there will be a long gap between CP1 and CP2.
There has to be, sorry sir, please come again.
If RFRP is delayed, there will be a long gap between CP1 and CP2 form.
RFRP is delayed. Yes, correct.
The CP2 form will be delayed.
Correct. Yes, there can be. So the authorities, they are not going to link from CP1 form. CP2 has to be filed within 75 days or something like that. They are not going to link it. But the form itself will capture when there is a delay by you. Why there is a delay? What is the reason? That form will capture that information.
No, nothing in between.
Yeah, you will have to justify if there is any delay. But they are not going to link when you submitted CP1 within so many days or you submitting in CP2. It may not be possible many times, there can be some extension. Stay might have been there, right?
Yeah.
Stay orders might be there.
Earlier, CIRP 7 used to fill that gap.
Correct, sir, correct. That point is right, The CIRP 7, whenever there is a stay, that has to be reported. Here in this case, RFRP will get delayed. So there is 1 year gap,
So
let's say.
We'll have to file CRP 5, sir. CP5, sir.
CP5, you can see, Mr. Patnaik.
Yes.
This is capturing the status of the CRP as on the last date of the previous month. So there you have to show what for I'm not able to issue the IFRP. Why I have not been able to do the RFRP, that information.
Right.
Okay. So 3A, 3B we have seen, 4 we have seen to report.
Sir, one doubt, sir.
Yeah.
In CRP 1, public announcement is to be uploaded within 7 days.
Okay.
In CP1, there is no timeline here. It is only talking about certifying COC by a constitution of COC.
Okay.
So this timeline is not there. Public announcement 7 days timeline is not there.
No, sir.
Yeah.
It is not there, sir.
Yeah, it is not. Yeah, it is not required to be reported in CP1. the public announcement is not going to be reported in CP1.
Not at all required to be reported.
Sir,
timeline.
it will be reported in the CP1,
Correct.
but not immediately within from the date of publication of them.
Okay. Got it. Please carry
The milestone linkage is removed from public announcement form to COC constitution report.
Yes. Got it, sir. Got it. Okay. Carry on.
Okay, so now this is up to CP5 we have seen, Raghu. Yeah, we'll go the next one. Objectives of the proposal. The compliance level is proposed to be reduced across multiple platforms, in the sense that once you start filling these forms and filing with IBBI, probably you will not be required to file certain similar information in the IPA portal. That is the idea, because they are trying to make these portals, work together, kind of recognize each other, handshake, and then pull out information from the IAP portal, IPA portal to the IBBI. IPs will be required to report the status and progress of the CIRP as on the last day of every month, as we have seen there, by filing the applicable forms within 10th day of the following month, except 3B. 3B is about the plan approval or liquidation approval or 12A approval, right? All these things. The end point is captured in the CP3B. Eliminate duplicate submissions, minimize time consuming for IPs. So earlier what happened, for each case, there could be, if a person IP is handling some 3 cases or 4 cases, each one will be coming at different point in time. So more or less, you will be always on the run to check whether I filed this form or not. This will be a continuous kind of an exercise throughout the month. But now they are making it all coming to 10th of every month. Okay, whether there can be a question like, wherever you propose a last date for filing a form or something like that, income tax, other, companies act related forms, there will be a huge rush in the site, the website. Whether this will be, the load of such kind of a rush will be handled by the IBBI portal is a question mark. But I think the committee which went into all these things, they have recommended that IBBI should have a very strong, the data network or the backbone. The server should be able to handle this kind of a traffic in the, data submissions. Eliminate duplicate submissions, minimize time consuming for IPs, except for form CP5, all other forms contains attachments of documents. This is a worry even for me also to share with all the IPs. Even the new forms also require attachments, and sometimes whether each month I am submitting. For example, I am submitting a form every month. Then repetitively that information has to be captured or not is the question. But let's examine the contents of each form. Okay, then you go to that the discussion paper, the annex. Some suggestions have already come from the participants, and I would definitely appreciate some more points. We have exactly another 45 minutes to go. So this is the discussion paper. Okay, go ahead. Yeah, we have talked about this existing framework, the forms, existing forms, right? Reduced to compliance proposal. Okay, now we are into the new forms proposed, suggested by the IBBI, CP1 form. You can just see that this form is to be submitted to IBBI by the IPA online by 10th of the month, succeeding the month in which the report certifying constitution of COC is filed with the AA under Regulation 17.1. So date of filing of the report under 17.1, due date of form 10th of the next month. This will be auto-populated. This is what they are saying. And delay in submission of the form. So they will also capture the number of delays and also reasons for delay. I don't know why they ask for reasons for delay. In any case, they are going to cost you, take from you the penalty of 500 rupees or whatever it is. I don't know. Then what is the details about the CD, all the information, whether names of promoters of the corporate debtor.
Yeah, also the going concern, number 11.
Senior number 11, we have come, whether going concern, yes or no, again it is there. Whether any proceedings, I think Santan Lakshmi was asking about this, whether do I have any information about the company being under CIRP. So this information, if yes, date of admission under BAFR. Again, another difficult question has come. So they are asking you to give the date of admission under BAFR. Okay, here I have one possible kind of information. When you are going to file this form, Raghu, you would have got at least a month's time.
Yes.
Now,
more than a month.
More than a month. Okay, in a case where it is admitted on first of the month, and you are holding on 27th filing. Okay, 27th you are filing, or 28th you are filing the COC constitution. You have only 10 more days or 12 more days to go. Okay, fine. More than a month is there. Then, if you can seek some information from the applicant creditor, applicant financial creditor, or applicant, I don't know, operational creditor, least bothered about whether it was under SICA or something like that, we don't know, right? So this information, probably, I don't know, you said it is mandatory or not. Is it captured here whether this information is mandatory or not in the discussion paper?
No, only when the portal comes, we comes to know.
So to answer the questions of some of our participants, we don't know which are all the information they are going to make it mandatory, but we can always suggest that this kind of information like SICA, date of admission should not be made mandatory.
Sir, one observation here is, sir, in all CRP forms, you will have one remark column under the at the time of submission. Just before that column, you will have remarks column. Whenever you are giving an information where you are not certain about this, you can give a rider there. Because unless you give the information, a star mark will be there and it won't accept for submission. In that case, I am giving this information under the premise, the following premise.
Okay.
And that if you give any remarks and submit, if form will go. If something happens tomorrow, you can claim stating that I have already informed like that.
Okay. So you are giving.
I suggest to all the participants to make use of that remarks column, which is there is no space restriction there. Whenever there is a explanation to be given, point wise you give an explanation there why you have stated like that.
I think in this case it is at the end of the form. I think I'm able to see something. Let's go ahead. B is about the insolvency professional. This is also already there in the last form. Admission of application by AA. I don't think
data filing to AA.
Data filing. So data filing. Who will have the data filing? The counsel for the applicant financial creditor or operational creditor only will be having.
Now it is stated that we can get these data from NCLT website.
Is it possible to get it from?
In this case, there is an application. Recently, we have to file the filing number also. While giving the assignment, we have to give the filing number. From that, you can know the data filing with the AA. So filing of filing number, uploading of filing numbers in all, even earlier cases also you have to upload. We have all uploaded even for the bygone old cases also. Now through that filing number with AA, you can have the data filing also.
Correct, sir. Correct. Okay. So if it is possible to be filled in, it is fine. Bench is auto-populated. It will come auto-populated.
No. If you go to NCLT site, through that case number, main case number, if you give, automatically it will pick up data filing, data of registration, filing number, all these things.
Correct, sir. Correct.
Populated here is editable, sir. It will show all the bench.
It will show all the bench. Yes, so it's a drop-down menu, you should say. Huh?
Yes.
Okay.
You can filter. We can filter based on the bench, sir.
Okay. Name of the applicant, petitioner, address of. If what Mr. Venkataraju says, if you have to just give that number, filing number or something. We have seen
case number, main case number.
16 digit code or something like that, then that information will be pre-filled here. If it is there, it is very good. Name of the applicant petitioner, name of address of the applicant petitioner, application file under section, okay. In case of section 9, whether the name of IRP was proposed by the operational creditor, yes or no. Even that information also they are asking now. I think this was not there in the earlier form. This proposal, whether the name of IRP was proposed by the operational creditor, applicant, yes or no. Maybe I think for statistics purpose they are asking how many cases of OCs who was recommended, whether has been appointed or not. There are many cases where they are changing the person also. Date of admission, auto-populated, editable. Auto-populated is, as you said...
Date will come, sir. That month will come.
DD MMYY.
No, the calendar will come there.
Calendar, okay.
So you will have to...
Okay. Like that, I think. Date of adjudicating authority order appointing the IRP, auto-populated, editable, and the date of receipt of order by IRP. I think this information has to be filled in only by the IRP, right?
Yes.
Fortunately, I think they don't have any access to find out when he has received it. There will be a lot of delays also in this process, right? 3 days, 4 days, 5 days also. Amount of underlying default for which petition has been admitted rupees, this has to be mentioned. Since when the amount in default is outstanding. So this is all required out of the application. I think this information has to be filled in. So you have to have an application copy from the creditors. Public announcement, date of issue, details of publication. I think someone wanted to know public announcement. So you have to mention that when did you go for the publication? Reasons for delay, sir. If there is more than 3 days delay, you have to say here what is the reason for delay. Good that they are not counting it by giving a date when you are published and what is today's date, how many days. Last date for submission of claims, auto-populated thing. Details of classes of creditors, any under 21(6)(a). I think this is the authorized representatives for each class, number of class of creditors. I think these are all probably, the same kind of information which was there in the earlier form. So now this is all in CP1, right?
Yes.
This is in CP1. Please go ahead. Process status, whether corporate debtor is listed. Fine, very good. Can be informed.
This question is tricky, sir.
Listed means what? Debt securities also or equity also? Anything is listed.
No, that clarity should be yes.
What is the problem for you to give this listed or not? Any?
No, that one, sir. Second one.
Second one. Has IRP taken into custody all records and assets relating to CD? Yes or no? If no, whether application under section 19(2) of the code is made to the AA. If no, specify the reasons. I think this is a very, very important kind of a requirement. So, what is the suggestion from our team, our participants, our audience? This particular E2, in many cases, it happens that there won't be anybody in the corporate data. You have to go and open a door or open, the premises of the factory where everything is in a sham. You may not be able to even find out what is there and which is there in which place. Supposing you say no here, I have not taken into custody. Raghu, there is a provision in CIRP regulations. You are not able to take over the custody. You take to witness and you prepare a kind of what are all the things there.
Yes, sir. Regulation 3A that has been introduced recently specify the modalities of taking the assets.
Correct.
But that also within 1 month, whether all these process filing, including filing of this 19(2) will happen within that 1 month period, that is a question.
Not possible. Not possible.
Not possible.
In the initial days, you may have the cooperation from everybody. After some time, there won't be any cooperation.
Absolutely.
So within 30 days, it is not easy to judge. In that case, you have to write the reasons specifying why you are not filing non-cooperation petition with AA. So if no specify the reasons like that, there you can use that your explanation there.
That,
Sir, good evening to you, sir. Sir, good evening to you, sir. My name is Bhuvaneshwari. I'm calling from Bangalore. Sir, I have one practical issue where in one of my assignments, the promoter is in jail and all other directors are absconding. There is not even one employee in the company. And there are properties which are locked by the promoter. We don't have the key. And I could not file non-cooperation application because there is nobody in the company on whom I can file when the promoter is in jail. Whereas I approached the court, NCLT, and they gave me order to take police assistance. And because of this election and all that, we were getting.
Hello. We cannot remember. Mr. Vijay. Hello, Mr. Vijay. Please mute your audio, sir. Thank you, sir. Yes, Bhuvaneshwari ma'am, please proceed.
Yes, sir. And because of the election and all, I could not get police assistance. Whereas the new regulation, the amendment says, when it is not being handed over in the presence of one or two representatives, I can break open and do a panchanama and take control. That is the new regulation. When I was talking to some of the established professionals in the field who are legal experts, they said, break open, you don't do it yourself, madam, and it will involve problem, and go to the court and get the order. In fact, I have gone back to the court because varieties of properties, varieties of police stations I am approaching. Police is not, they are finding ways to deny my request. One side they will say, property details should come in the order, or court Amina should come and serve the order to us, various things. So, in fact, I was for using this particular regulation where it says that in front of two representatives, the resolution professional can take control of the property. So, since it is newly introduced, in fact, I wanted to make use of it. Can I still go ahead based on this regulation and break open myself and do a panchanama and comply with it, sir? What's your view?
Okay, I think the question is away from the contents of the form and whether these forms are all okay.
You spoke about that particular thing. I'm trying to bring because it's useful for all our IPs actually, this question.
True, ma'am. There are practical difficulties in every case. I think each one of the participant here, the situation and circumstances will be quite unique. In relevance to this particular form, this particular E2 content, whether you are able to take custody of all records and assets relating to CD, you will say no. Am I right? Because somebody is in jail, somebody is in abroad, somebody is not cooperating. Then, if no, whether application made under 19.2, have you made it? You will again write no. Right? And then you will say the reasons, as Mr. Venkataraju said, you have to stuff here as much as what you said now, what are all the steps you have taken, and why you couldn't file certain applications. For example, if somebody is in prison, Raghu, if somebody is in the directors of the company are in prison, does it mean that you cannot file an application against them? You can, no? We can file.
We can file, sir.
But serving is a problem.
Yes, sir.
It can be served in the prison for them.
No, in that case, why can't we take assistance from the local district administration for filing an application with AA? This is the difficulty in taking the assets because non-cooperation only happens if they are available and they are not cooperating. If they are in jail, how they will simply say, I am not in receipt of any of the.
I have seen cases where certain court notices have been served on the people inside the prison. We have seen some Binami notices and all, that cases, it has been served. Maybe it is for high profile persons.
Even if it is served, notice being served, he will tell, I am inside the prison. How I will be able to hand over the documents?
That is true.
So in that case, I think an application can be filed under Regulation 30 for breaking open, seek the local assistance of the local assistants, where a police or other people will be there.
Yeah.
You can break open the asset.
Yeah, correct. Yeah. Bhuvaneshwari ma'am, to answer your question, in the interest of the professional conduct and then seeing today the kind of allegations and complaints made against the IPs, you please seek the direction or support of the local district administration under regulation
30
under CIRP. So, in the coming question.
No, whether
Sir,
regulation,
my humble
regulation
submission-
30 provides for a district administration to help the IP.
Yes.
It is?
Yeah.
Yes, sir.
Yeah.
Sir, my question is a bit different. Sir, when the CIRP regulation says that RP can break open the lock in the presence of 1 or 2 witnesses, why
Okay.
should I go to local administration and waste my time and energy on that and delay the process? That's the question, sir. Do I have enough powers based on this regulation? Can I go and break open?
Exactly.
No,
So
that's
even
what
I
I
was
was
just
thinking.
thinking the
That's
same
what I
thing.
was trying. Yes, ma'am.
The statutory itself is empowering an IP to break open the door. Then why do we need an approval from AA, sir? But when we file these kind of application, sometimes the benches are like dismissing the application, stating when you are sufficiently empowered by statutory by the code. Why are you coming here and wasting the court time of the court, precious time of the court? So
Madam,
when
where
statutory
it is
power is
empowered,
given,
madam?
Bhuvaneshwari ma'am, you were saying that you are empowered to break open and take possession custody, right?
Yes, sir.
You are referring to
Regulation 3A.
Regulation 3A, which has been introduced.
Yes.
Right. I think this has come with effect from September 2023.
Yes.
Okay. So the effective part of that regulation, where any asset or record has not been handed over or the list has not been provided to the IRP or RP, he himself shall prepare a list of such assets records while taking custody and control of the assets and records. And the IRP RP may, after taking such custody control, if deemed necessary, identify persons in whose possession these assets and records will be held. This is what I'm seeing as an enabling provision, but I'm not seeing you can break open and then take possession. Can you please tell me where exactly it is written?
Sir, my submission is that when I can take possession myself, most of the properties, nothing will be kept open. Everything will be kept closed if the company is not functioning.
Okay.
So how do I take possession and control? Because most of the companies under IBC, in my experience, is that all are locked down, closed down business, closed down companies. People are not available. So when that is the case, if I have to take control of the asset or the records, I have to break open. It's locked.
No, there can be a situation where after you break open and then take possession and then Panchanama, whatever you said, all this is fine. But in case you are having a neutral person, an authority, a local authority is also there to assist with you, which has been provided in the regulations.
Yes.
Are you saying that it is going to take some more time for me to seek the assistance to take them with me? Are you saying?
It's not so easy. It has not been. Even with court order, we are struggling across the country. We are struggling because in my peculiar case, we have properties across the country in one case, and varieties of police stations we have to approach. Around 25 police stations.
That's the reality. That's the reality you have to appreciate. Even with Supreme Court orders, this is happening. Okay, not in IBC cases, but in the instant case, this is my opinion. I don't have first-hand experience on this. Regulation 3A does not say the wording break open. Okay.
Correct.
When you do break opening, what happens is the law of the land, Indian Penal Code will operate. IPC 422 or 442 will operate. That is, breaking open somebody is a criminal offense. So when you say that IP is enabled under 3A to take possession, similar provision is also there in SARFASI Act. But the very fact of breaking open, it is not there neither in SARFASI nor in IBC. This is my opinion.
Absolutely.
Because
absolutely
that will capture IPC.
Correct. Well said, Mr. Matthew Taragan. See, this is the reality, sir. And then later on, you will find all kinds of accusations that certain items were there, which is not there now. IP is responsible, RP is responsible. All kinds of allegations are likely to come up. So my suggestion would be that in such cases to take the local administration support. There can be a different case where the factory is there, right? Only the main gate you are not able to access or go inside the premises. Then that is a separate situation. You can just have it open with the security guards, take a videograph and then record it, and then go inside, and all those things can be done. I'm saying this particular thing regarding inside the premises, some records are there, some assets are there, some properties are there, but we don't know what kind of things are there. Securely locked, and you don't have the keys of the premises. You have reason to suspect that some information, critical information or assets are there. Director is not here, promoters are not here, they are in jail. Then you take the minimal kind of precaution and care. That will be helpful in our own interest, because breaking open, I remember in one particular case, Bangalore, there was a property sitting here in Chennai. I couldn't open it. We got an order along with the police department only. They went and opened it, and then they videographed it. So that is always a better. Yes.
Hello. My only submission is that in that case, regulation, sub-regulation 3 and 4, 3 and 4 of this particular 3A sub-regulation, latest amendment 3 and 4 does not have any meaning as such, and it cannot be executable. It's not helping the IPs. That's my submission, sir.
Hello, madam.
It is enabling you, but with the certain required authorities.
Mr. Anil Singh, just 1 second, hold on, sir. Mr. Anil, 1 second, please hold on. Yeah. Yes, this is an enabling provision where it says that with some additional witnesses at the site, 2 people, and then making some record, create it, and then you take it over. But extreme cases, for example, there is a case where the company is there, servers are there, computer systems are there, right? But it is entirely locked. You go and open it, then only you can have access to the books of accounts. All those things are there. Now you break open and then go inside and then do whatever you want to do. There can be a complaint against you that you damaged the whole thing, and because of you only, you are not able to have access to the information. That possibilities of some allegation might be there. Okay, so that is where I think
there can be. I'm sorry for interrupting, sir. There can be a counter attack upon IRP or RP.
It has happened, sir. It has happened. Yeah, it has happened in many cases. Sir, please.
Sir, may I add something? Hello?
Yes.
Sir, may I add something?
Yeah. Tell me, sir, quickly.
Sir, this Bhuneshwari, what the told Madam Bhuneshwari, first of all, you have to go to the district magistrate or SDM, local SDM. You put some application there. The corporate data is not allowing, or there is suspicion is there. So he will give direction to the SP, and SP will provide the force. In such cases, I see that it is happened like that. You have to SDM. You have to go SDM, get a letter. And same time you go to SSP, so he will give direction to the local police. He will go along with the RP or RP and give the protection. That is already done.
Yes, that is done, sir. But only thing is you have to get an NCLT order, right? You have to take the NCLT order. You have to take it.
No, your NCLT order is the only what you have to appoint the IRP. It is sufficient.
Yeah, appointment is sufficient. Appointment is sufficient. You are absolutely right. Only you have to take this order along with this application. That's it. Nothing more, nothing less.
Then why regulation 30 says?
Hello?
Then why regulation 30 says you go to the AA and take the approval?
No, because
regulation cannot supersede the act. Code empowered the IRP or RP under section 1725 like this.
No, that is there. You take control, custody, all those things are there. But then it doesn't say that you forcibly, come what may, you take custody. It doesn't say, no.
From this order, from the SDM or from the magistrate court, we can take the order.
Yes, sir. Yes, sir. Exactly. Sir, exactly. That's what.
Did you give the direction to the SP? He will go with him.
In one particular case, I took the NCLT order, to the district magistrate, and along with that order, we went, and thereafter only we could get some support. Just because you are appointed as IRP or RP, and you ask them, you please come with me for breaking open premises, I doubt whether they will be able to come. But if there is a law and order situation, for example, you are IRP, and there is a factory, there is a labor strike is going to happen, dharna or something like that, you can always go to the district magistrate or collector saying that this is going to happen, please give me protection. That is fine. Absolutely, that's not an issue.
Sir, but to cut down the timeline, because it's a time-bound process, the regulation 30 says that the IRP may make an application. This is not a mandatory requirement. Order of IA appointment is sufficient. Number one, code itself give enough power to IRP or RP to do his duties. 3, IRP or RP directly can approach to the local administration or magistrate.
Okay. Sir, Mr. Ajay, I appreciate your point, but I think place to place, the implementation could come into some kind of challenges. But let me restrict myself to this form and then proceed, sir. I think we have got another some 15-20 minutes only. So attachments here. Yes, sir.
Thank you very much. Thank you very much.
Thank you, ma'am. Thank you. So this is form CP1, Raghu, right?
Yes.
Then what is CP2? We'll go now. CP2 is talking about 10th of every month. That is okay. In which the RFRP has been issued. Date of issue of the RFRP and date of form to be filed within 10th of next month. Delay, all those things. So what are the contents required in CP2? Now, Raghu, I'm going to file CP2 form now.
Yes, sir.
Right? So RSFRP I have issued, today is what, 26th?
Yes.
So 10th of July I have to file this form. Now when I file this form, I have to give the CD's name, details, all those things, and valuer data I have to give, right? Okay, go ahead. Information memorandum.
Yes.
Valuers, that information is okay, no? Whatever information is there about the recent delay for appointment of valuers to be captured here. And IM, date of submission of IM to COC, reasons for delay, audited balance sheet and latest provisional balance sheet. One second, please go back to valuers.
So the date of submission to COC, there can be a difficulty because the COC consisting of different members of the financial institutions. So the regulation says that the IM to be circulated only when non-disclosure undertaking or something has been given by the members.
Correct.
Supposing if some members is not giving the disclosure, I will not be able to circulate the entire COC to the members who have submitted the disclosures.
Okay. So prima facie, it looks like they will capture a date there, but in the exact form, how they are going to ask, we don't know. Will there be a kind of multiple COC members are there?
My question is, supposing in the COC there are 10 members, 9 members have not given the non-disclosure agreement undertaking, and only one member, can I say that I have circulated to the COC?
I would rather say you are issuing a communication to all the COC members. Look, gentlemen, my IM is ready. Please provide confidentiality and take it. So that letter will be the date of submission of IM to COC. And thereafter, they take their own sweet time, they don't want it, then we don't help it, we cannot help it. Yes. Reasons for delay vis-a-vis timelines, okay. Audited balance sheet and latest provisional balance sheet, you have to attach adala. You have to give a date of the latest audited balance sheet, date of the provisional balance sheet, okay. Whether CD is an MSME, okay. Then registration number, fine, very good, they are capturing. Whether IM contains the details as per requirements of 36(2), yes or no. If no, list the details not captured in the IM. So this is again a kind of a self-declaration, self-warrant, what are all the information required to be given and why you have not been able to give 36(2). I think it captures all information like about the production operations, manpower.
No, not production.
36.2.
36.2, it talks about the financials, debt, list of creditors, related party debt, employees, assets and liabilities.
Yeah, lot of information has to be given there, but what is required as per 36.2? Regulation 36.2.
Assets and liabilities, latest annual financial statement, audited financial statement last 2 years, list of creditors, particulars of the debt from or to the corporate debtor with respect to related parties.
These are all that listed information.
List of the details of guarantees, name and address of the members holding 1%.
Okay.
Litigations, number of employees.
Okay, there is some more information just been amended to add current status of the machinery production.
Yeah, company overview, including a snapshot, performance, key contracts.
Okay, so that is not insisted here.
No, it is.
That is now, also part of 36.2?
Yes, sir.
That is
details of business evaluation, fair value, other information.
So 36.2 calls for a lot of company specific information and also information which is useful to the resolution applicants before they make up their mind to bid for it. All this information, I think the format looks simple, but I think they are asking all the details here. Please go ahead. So details of PRAC is requested here. Okay, it was earlier also it was there. Request for resolution plan, last date for submission, and whether RFRP requires any non-refundable deposit.
This question is irrelevant, sir, because this question makes me whether thinks me whether I can go for a non-refundable deposit.
It should not be taken, no? Non-refundable deposit should not be taken.
Otherwise, there should be a confirmation that I have not taken a non-refundable deposit.
Non-refundable deposit. Looks like a little absurd, huh?
Yes.
If they are, whether it's anybody...
The regulation restrict the IRP to take a non-refundable deposit.
Okay.
But the question here is whether RFRP requires any non-refundable deposit. If yes, give details.
That means you can ask for a non-refundable deposit.
That is what?
If you are justifying it, it looks like.
It looks like.
It looks like. Okay. So this point we'll take it. Information memorandum attachment, RFRP including evaluation matrix, other documents to be attached, declaration. Okay. See, I'm seeing this declaration part of it. Earlier in the form it is there. Not there.
No, not
so. Now each form comes with a declaration.
Yes.
So here, like Companies Act form, Deepa ma'am may be able to tell us where section 447 will be appearing in every form certification. I am aware of provisions of 447 for fraud. So here they are saying IP having registration number was appointed so and so.
That was there, sir, earlier. That was there. But the second one, I declare that the content of the forms are true and best to the knowledge. I think that is not there.
Nothing material has been concealed therefrom. So this is a kind of more accountability fixed on the IPs. Okay, right. They'll be more careful. Next, sir. This is form CP3A. 3A, we were talking about before approval of the adjudicating authority, but up to COC approval stage.
Yes.
What are the things?
Once application is filed.
Okay.
Application for approval of resolution is filed.
Okay, so I think this is an important form, I will say, which captures up to resolution plan stage.
Yes.
Okay, so in this generally they will ask for the claims and what is the amount proposed, reliefs, concessions.
Here in this details of admitted claims,
okay,
they are asking principal amount, other amount including interest and penalties. But whereas the forms does not provide the claim bifurcation, the claim forms does not provide bifurcation of principal amount and interest separately.
Okay. Any views from the participants on this item, sir? This is CP3A.
Sir, anyway, we have this sort of information already with us. So filling it up is not difficult. That's my view, sir.
Breaker, where they are talking about interest and penalty, particularly PF claims, they ask both interest, penalty and all. But here they are splitting it only principal. Only principal they are splitting.
Yes, sir.
Okay.
No, if the form provides that the principal and other interest bifurcated separately, for our verification purpose, we will do these things.
Okay.
But I don't think we will have a separate principal and the other interest column separated.
Okay.
No,
So if
sir, I think we have the statement of account. We will be asking them to enclose the ledger statement or the statement of account along with the claim form.
Okay.
So from that, we will be able to verify because back papers will be submitted to us along with the claim form.
I'm just looking at
from government department, we don't get the breakup.
Yeah.
From the FCs and OCs, we will get the breakup easily. Others, I can't say.
Correct. Raghu, in the assuming, for example, we take Form C, claim by a financial creditor, there details of claim, amount of claim covered by security interest, amount of claim covered by guarantee. That's all. Details of claim, amount of claim covered by security interest, so and so, guarantor.
So there is no column for claim under process.
Yeah.
So the claim form don't have breakup.
Yeah, it should have.
In fact, we get it, maybe Form C, you may get it because you will require it for the calculation purpose, but for all other forms, no, you don't get it only. And then you need to chase the person.
Yeah.
So there is a lot of time getting wasted. And again, getting this accurately, I'm not sure because the partial or the rejections are there, then how much amount you rejected, how much amount you accepted for the principal and the interest part. So that always remain ambiguous.
Correct, sir. Correct.
If you have that incorporated into the form separately, then it is easy to do.
Yes, sir.
Yeah, exactly. That is the idea.
It will be a manual exercise from the IP side, and he will do it as per his decisions. He will mention it as per his decisions, which may be
correct.
Which may be correct or not correct, and it is very difficult in the case of, especially for the home buyers.
Yeah.
You have hundreds of claims, not filled documents, separate, wrongly filled or wrongly, Form B, they will file Form D, and they will come to you to accept their claim forms. So this is a huge difficulty, especially in case of the home buyer's case.
Yeah, correct. I think, sir, this idea of getting this details by IBBI, it looks like to me, which is not provided in the claim form, but there is one exception. If you take Form B for operational creditors, other than workmen and employees, there they are saying total amount of claim within brackets, including any interest as at the insolvency commencement date.
So in the form, it will be a consolidated figure.
Amount. Correct.
As Mr. Rajit said, it for individual, you will be as IP, you will be working what is the principal and interest, but as such, you don't have a data on that.
Supposing I am the operational creditor, I make a claim which is verifiable with the books of accounts of the company. 10 lakhs is my bill invoice, 10 lakhs. I add another 2 lakhs as interest in the claim form. So for me as the insolvency professional, I have the claim as 12 lakhs. I can split it here, 10 lakhs principal and 2 lakhs interest. But this information, whether financial creditors will be able to give, what is the principal? Because principal goes back to the original disbursement. Afterwards, they charge interest on interest, all those things, they come. That is all accumulated. The interest portion for a financial...
FC is a very clear idea about what is principal interest. You will be, although we may either have to drop this or we may have to amend the claim form, but from the FCs, definitely you will get it.
Sir, the COC members who are accustomed to IBC, who understand IBC, FCs mostly do that. OCs these days are becoming more educational. So in that also not much of the problems. The problems is basically with the government authorities who are filing the claims. The problems is with the home buyers or any other maybe ingredients or any other stakeholders who are coming by virtue of IBC. Let's say in case of Jet Airways, all the OCs who were the ticket holders. So who are in hundreds of numbers. They are the bigger problems in this. That's what my submission is. However, the IBBI takes a view that is okay to us, but this is what the basic submission is.
Okay, take a note, sir. Just one step behind, you go back. They are asking for a lot of dates, I think, drop down. Application for approval of resolution plan filed, application for initiation of liquidation, application for closure of CIRP filed. I think these are all the information they are asking now. Okay, go ahead. Application
for... Sir, sorry to interrupt, but this is relevant to this form 3A only.
Yeah.
Once the assignment is over, there is one closure data which need to be filled in, which is I think from Mr. Aniket normally sends that data or that email and they open it with individual case for the individual IPs. That is called closure data.
Okay.
So I will request IBBI to look into the data which is being asked for. Many of the time that data is also one of the repetition of the previously filled data.
Correct.
So either we make it as a part of the CP form only, or means I don't know how basically you are working with the data and how all other data are required. So if that data is also closure data is also fixed, we can make a CP form and then we can make a part of the dashboard so that we will fill it as soon as we file the other forms. That's
true, sir. I think they'll be working on it. I think once this is introduced, probably all the information is captured here. They may not ask you again closure data separately. So one thing I want to highlight here for the participants, the CP3A, they are splitting into different sections. So you open particular section and then fill up the data. Section 2 is for application filed for approval of resolution plan, right? Right, Raghu? So in that, various things related to that is captured. 3 is for liquidation application.
One more small suggestion. I won't disturb again.
Yeah.
Kindly tell your IT team to ensure that the savings provision is there while we fill up the form. It is very poorly, I should say that Bean is not working properly. Many of the time we fill part of the form and then we go and save and it throws us out. And entirely we need to do the exercise again and again. So many of the time what we do, we open the form, we take the screenshots, we go into the Excel form, then we start doing a copy paste because this saving enable that may be in the forms, but I'm not saying that many of the time close it out. So
very valid.
We need to fill the form 2 times, 3 times, 4 times, again and again. So that's what the limited request is, sir. Thank you so much.
Sure, sir. Sure. Thank you, Mr. Ajit. But by the way, I'm not the IT team of IBBI.
I'm requesting sir to convey it out.
This is for the ICSI to note.
Yeah. I will make a summary of the suggestions and then we will submit.
Sir,
fine, sir. Fine. So
regarding claims, there should be a column. Claims under process.
Claims under
प्लांट का नाम लिखो, एड्रेस लिखो और यूनिट हेड लिख दो, बस बाकी हम देख लेंगे.
Claims under process.
ऑफिसेज ऑफ कंपनी में
Okay, sir. Right. Sir, kindly mute persons who are not speaking. Kindly mute. Let's go ahead. Final resolution plan received. Final resolution applicant's details, right? And then resolution plan approved, and whether it is promoter or related parties or no. Okay, go ahead. Date of COC approving the resolution plan. Okay. Members' voting share is captured. Fine. Resolution plan, go ahead. Details of stakeholders, amount claimed, admitted, and then realizable. Okay, go ahead. These are all captured from the plan. Okay. The one point they are saying is that, claims under processing, he is saying, right? There is one point. When some claims are under processing, how we can go for the resolution plan? I think there is a clear process now, which are all the claims you have received. Before the resolution plan is considered for approval, within a week before that, all those things has to be placed before the committee, how it should be dealt with. I think there are certain provisions in the regulations which takes care of belated claims received. and not processed by the RP. By the RP, he may have to give acceptable claim or non-acceptable.
Which is not available with the RA, sir. RP has to process it.
Correct.
But which will not be available, which will not be circulated to the RA while circulating the RFRP and other.
Correct. Yeah. So has any implementing agency monitoring committee has been recommended, yes or no, has to be given? Yes, sir.
Point A and B.
In H.
A, sir.
Sorry?
G. A.
G, whether RP is part of implementing monitoring authority, okay, generally it will be yes. If yes, give details about the period and fee fixed by the COC AA.
Generally, this fee is being fixed by the SRA.
Okay.
It is not fixed by the COC
also. Correct. But I think there is a regulation now or require suggestions that the same fee paid to the RP shall be the fees applicable during the monitoring committee. It cannot be more than that. I think there is a regulation. I've seen that, it should not be more than the fee received during the CIRP period. Deepa ma'am, am I right?
Yes, sir, I agree with you. I'm also just trying to see if I can locate the regulation for it.
Yeah, okay, no problem. But I've seen that it is there. So here the idea, Raghu, they are asking the period and also the fee fixed by COC should be there. I think AA, how it can come? This is 3A,
Yes.
It's not 3B. So COC, if no, give name and contact details of the nodal individuals from SRA regarding the implementation of the plan. Okay. So this opens up a view that a person other than the RP also can be appointed as a nodal agency. Other details of resolution plan, very, what is that? Infusion of equity, bank guarantee, yes or no, name of entity post resolution. I think this looks like very haphazard, some important information, but bank guarantee means what? I don't know. In the resolution plan, whether they are giving any bank guarantee, if yes, bank guarantee amount. How far this helps, for statistics or any purpose, looks like little hazy, the information what they are asking. Name of entity post resolution. Supposing the resolution applicant says that I will change the name after resolution plan approval, then we can give post resolution. Otherwise, no change, kind of a thing only to be like, right? Okay.
Sir, but that is not relevant also.
Not relevant, exactly, correct. Exactly, that's what I was meaning. Maybe I can just make a point. What is the relevance of this question? What is the name of the company? If you see that way, there are many resolution plans where they will say, I will convert this company into a private limited company from public. That kind of a thing also is being mentioned. A lot of things are there in the plan. Okay, 3 is for liquidation, Raghu.
Yes.
So, okay, in this case, anything you want to highlight?
No.
Information relating to decision regarding the early dissolution also is coming here. Elaborate the reasons. Meeting date of COC passing the resolution for liquidation. Okay. Whether COC has approved a plan providing for contribution. I think here they are capturing, if you are going for a liquidation application, whether COC has considered all those 39 A, B, C, D, sale as a going concern or liquidator appointment. What is the fee for the liquidator? It's also coming here, no?
Yes.
Whether COC has fixed its consultation with the RP, the fee payable to the liquidator during the liquidation period under 39D. This has become, in cases, irrelevant because even after the COC's consent, I think in one case, NCLT has changed the person. The liquidator has been appointed as a new person based on earlier IBBI guidelines. Okay, anyway, please go ahead. Section 4 is for 12A settlement, right?
Yes.
I think this is what somebody asked. Reason for application for closure of CIP. What is it? Reason for application for closure of CIRP. What is that? We should say 12A, etc. Just go a little down. Premature closure of CIRP, 12A, etc. So there is a dash here. You can fill in 12A or something else also, right?
Yes.
It looks like.
Yes.
What can be the other way of other situations?
No, in many of the cases, NCLAT
Orders
the withdrawal of CRP.
Okay.
Discharges the company going back into.
Okay, so in that case, you will say that NCLAT order.
Yes.
Date of application to AA, whether the application accompanies performance bank guarantee, yes or no. This all captures about 12A.
Yes, sir.
So I think there is some kind of misalignment. So terms for withdrawal, creditor, debt, settlement. Creditor, debt, settlement. Terms, this is what I'm just looking at. The application is filed before constitution of COC, yes or no. I think this is okay. I think there is some kind of before constitution, date of COC approval, members, COC and distribution of voting share. Okay, so 90% should be coming. That's all in 12A. Huh?
Yes, sir.
Okay. In 12A, is it capturing the amount? That is what they are saying.
In Form 12A, if the operational creditor refuses to submit Form FA, the COC, it is a single sole financial creditor consisting, the COC is consisting of sole financial creditor. They have cleared the amount spent by the OC in filing the Section 9 application. The cost incurred towards the IRP fees and everything, they are ready to pay. But still, the OC is not ready to give Form FA. So in that case, whether COC alone can proceed with the 12A application, whether Form FA from OC is also mandatory.
Applicant is mandatory. From the applicant creditor who has filed the Section 9 application. Okay, Section 9 application you are referring to because he is the operational creditor.
Section 9, yes. But
So
they are refusing to give Form FA. Whatever the amount spent towards CIRP has been reimbursed. CIRP cost has been reimbursed. But still they are not giving Form FA. Whether COC has power to file 12A application through the RP.
No. COC has the power to say yes or no, vote on the 12A, but voting on the 12A is with a Form FA.
As far as voting is concerned, OC is not at all a part of COC. So voting is 100%. For filing 12A, voting is 100%. So when there is a minimum of 90% of voting for closing of CIRP, we can proceed with the Form.
No, there is no 12A in this case because he is not giving Form FA. There is no 12A. Am I right, sir?
Yes, sir. IRP cannot bring this closure unless he receives a Form FE.
I don't think there is any question arising at all. Unless he gives FA, how the IRP will move? IRP or RP, how he will move? He will not move ahead, no?
Because he is applicant before the NCLT, na? So applicant only has to withdraw the case.
Exactly. Sir, Section 12A read with Regulation 30A of CIRP regulations, 30A clearly says that the application should be made in Form FA accompanied by a bank guarantee. Therefore, if you have to comply with Regulation 30A, you will need the Form FA from the applicant OC only.
Correct, absolutely. Absolutely. So this application, so this form also, this form also is not, terms of withdrawal, it's not very clear. This form also probably, drafted in a hasty manner of kind of a thing. Whether it captures all the information, there is a doubt. Okay. Please. Sir, Mr. Vijay, please kindly mute your audio, sir. Mr. Vijay. Common information to be filled in all the three scenarios, A, B, C. So A, what do you mean by A? A is valuation related information. B is avoidance transactions, whether RP has formed an opinion. Suppose there is one 12A. So in that case also avoidance transactions, if it is there is anything, then you have to mention that. Suppose 12A is done within a month or so where valuation has not been done, then you have to say nil or something that.
Yes, yes.
So here, whether it is mandatorily, it has to be filled in or not, we don't know. When the form comes, then only we'll be able to have that. Okay, then total value determined for preferential details of employment. Why they are asking this employment details here? Number of employees at the beginning, CIRP period, as on the date of filing this form.
No, this part comes with the approval of the plan or either liquidation, sir.
Okay.
Approval of liquidation.
Okay.
So this details is required with relating to employees.
I think they are capturing this information about workmen employees from PF kind of objective also, perspective maybe. Amount of interim finance if availed, date, amount, provider, remarks. There could be many parties and many dates, right? So whether this will capture, for example, in a COC with 10 people, so they would have given on 10 different dates, the contribution amount. What is the intention of the date, amount, if availed? I don't know. I think this may also give some kind of difficulty in filing the, because, we are asking contribution for CIRP expenses in different timelines, right? Intervals.
Whether that can be called as interim finance.
Otherwise, what? Then you need not have to pay it back?
No, we'll have to pay it back. But
Deepa ma'am, what do you think the participants, amount of interim finance if availed, supposing we are asking the COC members contribute towards the CIRP cost, whether such contribution to a CIRP cost should be called interim finance or not?
In my opinion, it is saying that if you read the regulation, it is saying the fees can be paid from the funds available with the corporate debtor or contributed by the applicant or members of the committee or raised by way of interim finance. So there are three different modes given in the regulation. Therefore, I feel interim finance should be different from what is contribution by the members of the COC. So I am referring to regulation 34B of CIRP regulations, sub-regulation 5.
Insolvency resolution process cost. So in that case,
I'm limiting myself to the fee paid, but still where they are giving a reference to interim finance, I feel it should be separate.
Sure, you were talking about only the fees to the IRP and RP.
But there is a reference to interim finance there. So therefore, I can only assume that this can be done across all CIRP costs.
Interim finance, if it is given not as contribution, is to be given here. So for the purpose of paying CIRP cost or liquidator fees, whatever it may be, sometimes the COC is asked to contribute. Then it amounts to contribution only, not as finance. Okay, because COC in all matters doesn't mean they have only finance creditors. In so many cases, they have operation creditors also. In which case, operation creditors cannot give finance. So then the term is contribution only, not finance. If it is for the purpose of CIRP cost. Okay, over and above that, if any finance creditor or COC member is contributing, it is interim finance. Okay.
Okay.
It is contribution towards CIRP cost. It is pure contribution.
Okay.
Right.
So this form does not ask any information about the contribution. Does not ask. It's only about the interim finance. Okay. Right. Is it asking about any interest on interim finance and all? No.
No.
But the provision says you can pay interest?
Yes.
Okay. So this is CP3A and then attachment. There you see form FA submitted to the resolution professional by the applicant. So this is for 12A, no?
Yes.
So this attachment is for all the things I think together they have written here. Application file for resolution.
Applicable attachment, we'll have to say.
We'll have to see the applicable attachment. Okay, so here form FA submitted to the IRP or RP by the applicant. So I think for her query, form FA, unless it is given, then it cannot move forward. Okay, go ahead, sir. 3B. 3B is the plan approved by the COC So here I think
3B is plan approved by the AA.
Liquidation also.
AA, sir.
Yeah, AA, correct. AA plan or even liquidation order or
yes.
Process closure. What do you mean by process closure? 12A. 12A order.
Yes.
Maybe a 12A order or okay. So I think they are giving one more kind of a category there, process closure. Others, please specify. I think there is again one more residual column also there in B. Okay. C is for resolution plan. Okay. Fill selected A above. Details of liquidation if B is selected. Okay. Contravention of resolution plan, approval on application. Okay. RP to resubmit edited 3A also. What is it, sir? Please specify the reason. E, closure or withdrawal. Slightly go back. 3A means CP3A, I think.
Yes, sir.
So here, I think CP3A pre-filled to append if applicable. I think they have to tick it and then it will be pre-filled. Autofill kind of thing, I think they are providing. Attachment copy of resolution plan, order of AA approving the resolution plan. Okay.
Sir, here one more suggestion is, sir.
Yeah.
Sir, this form needs to be submitted within 7 days of order, court order. In most of the cases, we don't receive the certified copy within 7 days.
Yeah, I think, sir, we have already taken note that, the timeline has to be enlarged. It cannot be within. Yeah, in this case. Yes, correct, sir. Correct.
And one more thing is this form does not capture anything about the cost related things. Earlier,
in the
CP3B, 3A.
Go back a little. The total cost incurred or something.
Yes.
See, this is all they are trying to give it to IBBI. As of now, they have not touched the IPS. So there you are giving all those details. Closure of CIRP, you are giving the cost incurred details once it is closed.
Yes, sir. But now this CP1 to CP5 combines the relationship disclosure, all these things.
Okay, but cost they are not capturing it here. Okay, we'll make a mention. Cost not captured in CP3B. Okay, sir. 4. This is regarding the avoidance transactions, right? Avoidance transactions. Due date of filing and then date of filing. Due date of filing applications under avoidance transactions. Multiple submissions of form to be allowed as applications may be filed on multiple dates. Yes. Okay, so in your case, there can be more number of CP4 for the same company.
Yes, sir. Earlier also, we used to file more number of CP6, CIRP 6.
Okay, so this is more or less like the same form. The contents, if there is anything, irrelevant or timelines is okay, 10 days from the date of filing and then it goes to the month end, right?
Yes.
10th of next month. Yes. Okay, not 10 days. Corporate data details, transactions, additional rows to be added on each filing by RP, date of filing application, filing number of days taken for filing application. Number of days taken for filing application means from the date of commencement of CIRP.
Yes.
Delay in number of days for filing the application is of its timelines. Any suggestion, any points on this thing participants may highlight. Then they are asking category-wise. Parties to the transaction, 43, 44, the relationship, nature of preferential transaction, date of such transaction, underlying amount, remarks. I think this is to be captured in the form. So in a case where you have multiple number of people, this form could be running into many pages. Plus, extortionate, fraudulent, combinations of extortionate, all those combination to be mentioned by IP. Additional fields to be updated by IP when application is adjudicated upon AA. Additional fields to be updated by IP when application is adjudicated by AA. That means the same form
you have to
update
yes.
Within the same month end plus 10 days time.
Yes, sir. From the date of order.
Okay, from the date of the order and the timelines.
So earlier, the form CP4 is to be filed. Once you file the application, the next month 10th you will have to file it, and from the date you will have to file. You will have to update the order.
Okay. Okay. So go ahead. Attachments, copies of forensic audit report, copies. There is a difference they are making: forensic audit report and transaction audit report.
Yes.
Earlier, we used to say only transaction audit report. Now there is a forensic audit report also has come, if any. Application filed with AA, order passed by AA, order passed by other courts. Order passed by other courts means the application filed in several other forums also. How does it come? Documents, if any, to be attached with a brief description against each document. There is a possibility of any other civil court or something giving. It looks like, they have given, like, claim determination, tribunal or any other court, something they are asking. Similar to that, they are asking here, avoidance transactions, can there be any other court involved? I'll make a note of it. Okay, so go ahead. So this is 4 as CP4. Okay, CP5 is regarding that times are Raghu to be filed.
My understanding is when I'm going through the form, we see one person was asking that CP1, the gap between CP1 and the CP2 is very large. I think in this form, we'll have to fill every month, describing the stages.
Correct.
If you go down,
go down.
The second current stage of CIRP, there will be a radio button. So when you do a public announcement, report certifying, this will come in the first month.
Okay.
Information memorandum, other thing, expression of interest, anything is being triggered, the next month it will come.
Correct.
So till resolution, the RFRP, so this CRP 5, irrespective of CRP 1 to CP 1, 2, 3, 4, irrespective of that, any event is triggered, this CP 5 will have to be filed, I think so.
Okay. So if the radio button is not clicked, then that activity is not completed.
Yes.
Okay. So you have to fill in some information there.
When the radio button, you click the radio button, it will
completed.
Yes.
Whenever it is completed, you have to click it and then give the details there. So it looks like
the next stage it comes what they are asking.
Okay. Stage specific details. Complete only the section relevant to the current CRP stage as mentioned in section 2. So they want that, earlier public announcement one by one separately comes again.
Yes.
Okay. So you have to enter the date of issue of public announcement. Okay. So this comes, Raghu, where I have already filed that CP1 date of filing. Now here I don't have to do it. If it is delayed only, I have to come here.
No, sir. Public announcement is issued. You will have to say public announcement is issued.
Okay.
Supposing information memorandum, for example, you will be giving the information memorandum, but not to the COC. I think in 60th day you will have to give.
Okay. So that date and then when you have done it yourself.
Yes, sir.
Okay.
So once you give the information memorandum to COC, there won't be any CP forms to be filed until you issue RFRP. But this CP5 has to be filed as soon as you issue the IM to the COC.
But CP5 also is every month, right?
CP5, any event is triggered, sir.
Any event is triggered.
Invitation to EOI, information memorandum. Process event is triggered, you will have to file CP5.
And the date for filing it?
10th of next month.
10th of next month. So even though the events are happening on different dates, it is not like your only CP3B, the dates will be varying.
Yes.
Other than 3B, all these things are coming to the 10th of the next month. Okay. So you are saying that even though I am filling CP1, for public announcement, reports certifying constitution, right? I'm filing CP1.
Yes.
Here also you have to give the date.
Yes. Yes.
Is it not duplicate?
It is not duplicate. Only through CP1, what stage you have come, they can monitor. The IBBI can monitor only through CP5. They can monitor you at what stage you are there.
Suppose I have filled up CP1, formed the committee COC report, filed everything. The CP5 will be auto-populated?
Maybe that once the form is made enable, we'll have to check.
Okay, complete only the section relevant to the current CRP stage. So I think there is some kind of ambiguity. Section 3, Section 4, what is there in this? These are all only dates they are capturing.
Yes, sir. Yes, sir.
Minutes of the COC meeting conducted during the month. Date of meeting, meeting number, attached copy of notice, minutes, voting results.
So now every month there should be a COC meeting.
Correct.
So every month you will have to file CP5.
Earlier, every meeting minutes only we were filing.
No, sir. IBBI will not be filing the minutes. IPA will be filing the minutes.
Okay. So now these forms are introduced and implemented. You will be filing the minutes here in IBBI website. So there it should be dispensed with.
Yes.
IPA.
Yes. Totally any filing, I think, from reading of this discussion paper, there won't be any filing with IPA, sir.
Okay. Yeah, all this comes into the same platform, only one platform.
Yes.
Okay. Okay. Section 5, details of all IAs filed with the AA regarding CRP of CD with respect to all entries made in this section, the rows of issue in brief and outcome to remain editable in subsequent months too. I think this is going to be like all IAS also everything they are asking. Huh?
Yes.
This form is going to be a real pain, I think.
Yes.
CP5.
Yes.
One observation here regarding sharing of COC minutes to IBBI.
Yeah.
There is one guideline stating that you have to inform to AA bar IBBI regarding the major issues of the assignment.
Okay.
They have not defined what are the major issues. So it is better to share the COC minutes at least to save our skin.
Okay.
Yeah? They have not defined what is the material development. There will be some sort of material development in every COC.
Yeah, correct.
So it is better to share all COC minutes by mail or through uploading in the portal of the IBBI. Anyhow, it is better to actually, as per rule, every COC minutes has to be filed with AA through an interlocutor application, basing on the same regulation. So you have to keep the AA and the IBBI informed of every material change. That is the guideline. There is a guideline. Please, one of my friends may refer that. But they have not defined what is that material change.
Where is the requirement that COC meeting minutes should be filed with IBBI?
No, such a requirement is not there. But every material development has to be reported.
Okay.
So what is material development is not defined.
Where is that, sir? Material development to be reported?
I will get through it. Some of the participants may please help me, sir. It is there.
Yeah.
It is there in CRP regulation.
IIIP, there is a requirement. We have to file all the minutes, sir. No, ICS.
Okay, that is IPA, sir. That is, I appreciate that. But in IBBI, CRP regulations, it is there, stating that you have to inform every material change, material development to the AA bar IBBI. But they have not defined what is material development. So holding COC is material development.
No, sir. If material development is to be reported to IBBI and AA, there will be lots and lots of IAs before the adjudication.
They may not release. AA may not release this, but regulation is that.
No,
I will refer to regulation and say, I will inform you now itself.
Yeah. Let's check it out. To my knowledge, it is not there because COC is responsible and procedurally RP is responsible for all filing or compliances, if anything is to be brought to the notice of adjudicating authority, resolutions are required. In most of the cases, like extension or something, extension or approval or removal of replacement of a liquidator or IRP or RP, all these things are application going to adjudicating authority. But in any case, Mr. Venkataraj will look into it. Please go. IAS are to be filed. Definitely it is going to, particularly in large cases, there can be so many IAS, right? Everything has to be brought in here. And why they are talking about only IAS? Suppose it goes to NCLAT, Supreme Court. That is also called IAVA. Maybe, huh?
I will come with the regulation, sir.
Yes, sir.
Liquidation, there is one question for us, because every quarter you need to send quarterly progress reports. So all these year COC SCC minutes of that month, that quarter, maybe all the 3 are 1. You can submit and you are fulfilling that guideline.
Yes, sir. Yes, sir. In liquidation,
holding COC monthly is not mandatory. You can take a consent of the COC and you can hold the same quarterly also, as per latest guideline.
Yeah, at least in a quarter there has to be one meeting. That is it.
Yes.
Yeah. Raghu, cost disclosures is coming here.
Yes, sir. That is also.
Cumulative figures.
Yes, sir.
So now
this cost disclosure, cumulative figure, whether it is approved by COC or.
I think there is going to be some annexures for all this.
Where
forms.
I can cut.
No, there are some annexures here. We'll just look into it. Relationship disclosures is coming here. Then declaration. Okay, go ahead.
No, that's all, sir.
No, there will be some annexures like
no, we
expenses.
Have come to the end, sir.
Expenses and all, there were some annexures.
No, we have come to the end of the circular.
Go early, little early. Above. Some bank data, opening balance, that is in liquidation process guidelines.
Yes.
Okay. I think in the recent past, there has been 3 discussion papers. One is this forms, second is liquidation.
CIRP amendments is there.
CIRP amendments and the liquidation regulations.
The format of the progress report.
Format of the progress report. I think it has come in a very big way. So, sir, I think, ladies and gentlemen, we have come to the end of this form. Whatever new forms have been declared. Yes, Mr. Rajkamal, you want to say something?
Yeah, I want to say something. I have got one observation that in the new system, the accept CP3, all the forms needs to be filed on 10th. And there is a tendency that everybody files on the last day. So there will be heavy pressure on the system to file these forms. So I think it will be better. It will be better if the IBBI scatters the dates for the different forms, say by alternatively for 2 days, so that it will not have a burden on the system. That is my suggestion.
True, sir. But I think even income tax department also, every year you feel that you are seeing the returns are filed towards the end of the last date only. I think they are improving. I think in the initial stage of our discussions today, I was saying that the data backbone, the network data arrangement, IBBI has to strengthen because they are bringing into a 10th of every month window. So there will be pressure, there will be kind of traffic will be there heavy and systems might slow down. But the suggestion of bringing 10th uniformly is in the interest of the insolvency professionals. But the problem will be, we'll be sitting before the screen and then it goes round and round and round. It is not able to complete the process. I think your point is well taken. I will make a mention that rather than scattering or deferring the dates, the data system network, they have to strengthen it, the capability of the systems.
If the system is strengthened, then the issue doesn't arise. But if it is not there, then every IP will have a problem, and later IBBI will come that you have not filed in time, and the penalty will be there. That is what.
Correct, sir. Correct. Of course, it is not like income tax return. Income tax returns is in multiple quantity volume, but here the volume will be less. Attachment and other data can be a big drain on the thing. Yes, sir. Any other suggestion? Any other points from the participants, sir?
Sir, Form 1 under Regulation 46(5) of Insolvency, liquidation process regulation, sir, with respect to unclaimed deposit of unclaimed dividends or undistributed proceeds, that amount realized after distribution. So, can I ask that question? Is it relevant for this session?
It's absolutely not relevant, but it is relevant for the
We are
profession,
discussing
probably
only
not the.
CIRP forms, not the liquidation forms. Is it, sir?
Yeah, but still.
During the liquidation process, after the amounts are distributed, the undistributed dividends has to be deposited with the IBBI. For that one form 1 we are filing. For that we need to get some acknowledgement that we are not getting, sir, on time. And even the company itself is dissolved and everything is over. Now, what is the remedy? Like we are not getting any acknowledgement from IBBI.
There are many such
amount undistributed is transferred to IBBI for the reason that we are not able to identify the beneficiary. In my case, actually, those employees who were working in 1970s or 1980s, those whereabouts are not known, and there is no records at all to find out their
corporate liquidation account.
Then how that the claims were processed, madam?
For those who are working or their whereabouts are known to us, we have distributed to them. These are actually received from PF, like dividend, PF office, their funds, PF funds. Sorry, not PF. Is that?
Okay, in any case, Santanalakshmi ma'am, if you have some amount, you are not able to identify the recipient of that money, you have to deposit it in CLA, corporate liquidation account, right?
Yes. After depositing, we are filing the form. So this is the amount. It is actually the beneficiary name is this, but whereabouts are not known. There is no contact details. How to reach them, how to transfer the money to them is not known to us. So that is the reason why we are transferring to that account.
Correct.
So now for that, we are not receiving any acknowledgement.
So from the IBBI, you are not getting any acknowledgement.
Yes.
Okay.
In no cases, IBBI gives an acknowledgement.
IBBI probably in many situations it's a one-way street. It's a one-way street. So what you can always do is.
Can we assume that our responsibility is over after depositing the amount and filing the form?
Keep a copy of your email to them, address to them, and in that email, you please make a mention that in case I do not receive any reply within 7 days, I assume that you have received the information and you are doing the needful. Something like that, you can put it for your own thing. Okay. I think they are trying to do some improvements, but the process is little slower.
In our cases, they were asking an additional data to be submitted to them. You are telling that what are the actions taken from your end to distribute? Give the proof that the actions taken by the liquidator to distribute, and it was not possible. Those backup data they were asking from us.
Yeah.
Those data are not available. That's why we couldn't transfer itself. So again, I received repeated emails seeking some more information which is not available with us.
Anyway, ma'am, I think the best way is to inform them by email and keep a copy of all those things with you. Anytime they can reopen and then ask questions. So thank you very much. Thank you very much, participants. And
Sir, I have one submission regarding.
Yes, Mr. Patel. Chetan Patel.
Yeah, existing CIRP 7 form and proposed CP5 form, sir.
Okay.
Sir, the intention behind this CIRP 7 is to make update IBBI regarding the important event like public announcement or issue of IM, which has not been done in due time. So the intention is that only. But sir, once the resolution plan has been submitted with the adjudicating authority, I think IP has not too much role to play. And even 2 years time has been taken by the AA for the approval or a rejection of the resolution plan. And for that 2 years, IP is required to file this CIRP 7 form and maybe CP5 in future. So my suggestion is that once the resolution plan is submitted with the AA, once updation is sufficient, should be sufficient to the IBBI.
Okay. But how IBBI will come to know that there is a delay in other processes? You are saying that about the resolution plan submitted, that they will come to know from 3A and 3B. 3A has come, 3B has not come. So they will find out resolution plan delay. But other compliances delay only, they are asking CRP 7. Am I right, Raghu? CRP 7 and CP 5. CRP 7 and CP 5. Okay, sir.
Sir,
in
after
these
submission of resolution plan, I don't think anything will be left out.
No, sir. After submission of resolution plan to adjudicating authority, even now COC also is existing. There is a amendment.
Yes.
And anything not to disturb the resolution plan already filed, the COC can continue the operations or proceedings. That kind of an amendment is there. So you cannot say, I have filed the resolution plan with the adjudicating authority. I have a case where I have filed it some 3 years before the resolution plan. I think, am I right, Ila? 2021, we filed it with the NCLT for approval of a resolution plan. Till now, it has not been cleared. So 3 years.
We are filing CRP 7.
We are filing CRP 7, and company is in operations. And since there is a stay, I'm not able to even have a meeting of the COC also. The RP is under authority, responsibility to take care of the day-to-day operations. So this is how I think it is happening. And now, because of the CIRP 7 only, IBBI is knowing that this plan is getting delayed. This plan approval is getting delayed by the adjudicating authority. So in my view, Mr. Chetan Patel, your view that once the plan is submitted to the adjudicating authority, my hands are off from the process. Please don't ask me any further compliance. Might not be the case, I think.
In CRP 5 also, there is a column that resolution plan submitted to NCLT, submission date,
correct,
NCLT filing number, next hearing date, reason for delay.
Yeah. Sir, I think, sir, the idea of IBBI is to find out where all matters are getting clogged, where there is some kind of a stagnation, where to push the pipeline, bottleneck is there. I think that is the idea, I think. Somebody else wanted to say something, sir.
Sir, it is me, sir.
Yeah.
Sir, there is lack of monitoring at both IBBI and IPA level. They know that some forms have not been submitted. Of course, I am talking about the present regime. Some forms have not been submitted, like CRP 1 or 2 or something like that. They are not following up with the members. It is coming to light only when you apply for AFA renewal, and your IPA will ask so many things. You have not submitted that form, this form, like that. And as per bylaws, both the authorities, both the regulators are supposed to follow up with the members, which is happening only at the time of renewal, AFA renewal, and it will indulge the payment of so much huge penalty. I am the culprit in most of the cases. I am very surgical in my system, in my actions, but I was made scapegoats in so many cases. I don't want to name those things, but the thing is, the monitoring is not happening at both the levels. One thing, sir, I have just this thing.
Venkataraju, sir, just 1 second, sir. Are you saying that the regulator should give you a warning before catching you wrong that you have not submitted this?
In many cases, it is happening like that, sir. CRP 5 is accepted, and they are the IPA is asking for so many forms. So clause of year is accepted at IBBI level, and the IPA is asking for so many disclosures and all. So by which time you already followed. That monitoring is not happening. I don't want to name.
You use the
in
word
every
follow.
case, every year I am having one case or other because I don't have so many cases. But I found I don't want to find fault with anybody. But monitoring has to happen through auto generation of mail. One mail will make you alert. Okay, of course, payment of course penalty cash upon you, but at least that monitoring guideline is there. Monitoring guideline is being invoked only at the time of AFA renewal at IPA level. I have faced it during the last 2 years. Okay, that is one thing, sir. Another thing is the duplication of information has to be filed. I'm talking about the present regime only. and the cost disclosures and everything you have to key in at both the places. So this data redundancy is to be removed with the introduction of new forms.
Yeah. Sir, I think that is the idea. That is the intent. Yeah.
As already told, alert through SMS or email should come from regulator regarding submission of forms. As Madam already informed about filing of that surplus proceeds, where acknowledgement has to come.
Okay, sir. Okay, that is fine, sir. That is fine.
Okay, there is. I don't want to comment. But in the IBBI software, I had faced a very bizarre situation when there was nothing wrong on my part. I was asked to pay a penalty and claim from them because the software doesn't allow exception at any level. Because that form due date of the form it automatically populate and you have nothing to say. Even if you give reasons for delay, even if it is not attributable to you and rather attributable to IBBI level, they are telling you pay penalty and claim from us. They are sending one Excel format and asking us to pay payment to claim that. I have claimed twice like that. I told them I am not the culprit. You are asking me to pay a penalty. It is effects on my morale. Even then also they told that there is one circular in 2018 of IBBI stating that for software mistakes, if anything is paid inadvertently or purposefully by the member, they can claim, they cannot question IBBI. Like that in 2018 circular is there.
No receptor for penalty.
Yes, I am the culprit, I am telling. But there are so many problems with software, sir. Because they know that this is not attributable, there is an exception. In banking, there is an exception by higher authority. If system is claiming for putting any penalty on you, the higher authority, maybe general manager at higher level can give a exception in back end, so that you need not pay penalty. But here, what is happening now? You have to pay, and you have to claim.
Venkataraju sir, all points you are mentioning, all points you are referring here, definitely I think they are worthwhile. But one thing, sir, my word of caution to you is that wherever required, the responsibility is on our shoulders to comply with the timelines or filing. And if you are asking that the regulator should give you a warning signal or an alert signal, I think we can only ask for it as a request. It's an enabling kind of a mechanism, just guiding, giving you an alert message. You see in many cases, income tax department publishes in papers advertisements. This is the last date, countdown, 4 days, 5 days, please take note. Something like that. I think you are saying that it has to be given by way of a message. We will convey that message, sir. Don't worry, we will do that. So thanks a lot, all the participants today. I think we have extended the timelines. Yeah. So timelines is an essential thing of the code, but then many times we extend the times in the interest of.
Is there any chance that CP hour can also be granted some more extra?
I find someone from the ICSI IAP here.
Yes.
Okay,
Yes,
I will also make.
I am from ICSI IAP.
No, all of us are from the ICSI IAP. But from the institute, from the Insolvency Professionals Institution, if somebody is there, we'll make this request to them also to take note of it, ma'am. You are from which place, Sandhana Lakshmi, ma'am? You are in Chennai?
I'm from Chennai, sir.
Chennai. Okay. Thank you. I think most of the queries you have raised today, Maya and Sandhana Lakshmi. Thank you very much, sir. Mr. Venkataraju, I think you seems to be having a lot of concerns. Let's hope sometime in the near future, all your worries are addressed, sir. We would like to see you a happy person. Thank you, sir.
Okay, thank you, sir.
Thank you very much, all the participants for very active participation.
Thank you, sir. Thank you so much for your.
Thanks each one of you, sir.
Yes, sir.
Thank you very much.
Very much, sir, for such an interactive session.
Yes, Anjali. Is it Anjali?
Yes, sir. Thank you all the participants for such an interactive session.
Thank you. Thank you very much, Anjali. Thank you very much.
Thank you very much.
Thank you, sir. Thank you, Mr. Hariharan.